Then, welcome to the lecture series on transnational commercial law, celebrating the 40th anniversary of the CISG. My name is José Ângelo Estrela Faria. I'm the Principal Legal Officer with UNCITRAL. It's a pleasure for me to be here with you. The first lecture, we focus on the scope of application, the formation of the contract of sales under CISG, interpretation of the contract, and the obligations of the buyer. Today, we'll focus on the conformity of goods, obligation of the seller, breach of contract, damage, and exempting impediments under the CISG. And the definition of the scope of application of CISG is in terms of the geographic scope of application, the material scope of application, and then we'll also be talking this part about the interpretation of the CISG. The territorial scope of application of the convention. The convention applies to sale of goods, contracts for the sale of goods between parties whose place of business are in different states, when both states are contracting states of the CISG, or when the rules of private international law lead to the application of the CISG. The fact that the parties have place of business in different states is to be disregarded when that is not apparent from the dealings between them. And the other important notion on the scope of application of the CISG is that neither the nationality of the parties nor the civil or commercial character of the contract has any relevance for the application of the CISG. What does that mean concretely? We'll see now. What are contracts for the sale of goods? The CISG itself does not define sale of goods, but is generally understood as a contract whereby, like in most legal systems, parties exchange goods for money, regardless of whether under domestic law that contract could be considered to be civil or commercial. As you know, many legal systems use that distinction for various purposes, including for the establishing jurisdiction over claims. That for the CISG is irrelevant. The CISG also covers partial sales. That means a sale where delivery is by installments, or also payment is by installments. Direct sales to the buyer's customers. Sale of goods to be installed on land, meaning the fact that the goods sold eventually become part of an immovable property does not prevent the application of the CISG. And sale of goods that are not intended to be resold. As you know, many legal systems, in particular civil law legal systems, regard commercial sales only those that are made for resale and not for a person's own consumption. These criteria are all irrelevant for the CISG. Now, as for goods, the CISG adopts a rather conservative definition of goods. It doesn't define goods, but the understanding underlying the CISG is that goods are movable, tangible objects, regardless of their shape or whether they are used or new, whether they are solid or liquid, whether they're inanimate or alive. So it covers the sale of live animals, it covers the sale of objects, as it covers the sale of gas or any other tangible element capable of being contained in a container. From a geographic point of view, it covers sales when the parties are located in two different states. That's the first thing that is important. If the sale that is purely domestic would obviously not fall under the application of the CISG. When both states are contracting parties to the CISG, if that is the case, say, a contract of sales between a French seller and a German buyer, and a dispute arises and goes before a German court, the German court doesn't even have to look into its own rules of private international law to determine which is the applicable law. The CISG applies automatically by the virtue of the fact that seller and buyer are both located in contracting states of the CISG. That's what one calls the autonomous application of the CISG. And then we have the non-autonomous application of the CISG. That's the second circumstance under which the CISG could apply under Article 1. And that is when the rules of private international law lead to the application of a state party to the CISG, except in those countries that have excluded this possibility. And you have here on the screen the list of countries that do not apply that. What does that mean in practical terms? First of all, this obviously only binds the courts of a contracting state. Because if you're not a contracting state of the CISG does not apply in your country, right? But if you are an Italian judge, for instance, right, and you have an international dispute, and the other parties say the buyer is from the United Kingdom, the seller is in Italy, the buyer in the United Kingdom, the dispute before an Italian court, the Italian court would look at the case and ask itself, which law has the closest connection with this contract? And it's the law of the seller, usually, in most legal systems. And would, by that provision, apply Italian law to the case, even though the United Kingdom is not a party to the CISG. What happens if countries have excluded that possibility? For example, the United States has excluded that. It means that a case involving a seller in the United States and a buyer in the United Kingdom goes before the commercial court of New York. And the judge in New York, let's say the CISG is not autonomously applicable because the UK is not a party. So I have to look into my own rules of private international law to determine which is the applicable law to this contract. The applicable law is US law, because US law also would say that the closest connection is the law of the seller. But the United States would not apply the CISG. It would apply its own domestic law. And that's the effect of that exclusion, excluding the application of Article 1.2 in those countries that have made that exclusion. Now, can you choose the CISG to govern your contracts? And here, the question will depend on who is ultimately competent to hear that dispute. Arbitral tribunals enjoy great freedom in the application of law, or better said, the parties to a dispute that is being settled by arbitration have greater freedom in choosing the rules of law that will govern their dispute. Because in arbitration it's possible not only to choose state law, you can also choose other rules of law. That's the term used in the, for instance, in the rules of arbitration of the International Chamber of Commerce, the ICC, rules of law. Rules of law encompasses not only state law, but also other sources of law. Well, where the CISG is not automatically applicable on its own terms, because, for instance, the party is not yet, the country is not yet a party to the CISG, it's still possible in arbitration for the parties to agree on the applicability of the CISG as rules of law. And an arbitral tribunal would respect that and apply it. That is, however, not the case if the dispute is being heard before a domestic court. Because domestic courts, in most legal systems, this is beginning to change slowly, but still in most legal systems, domestic courts only apply the choice of a foreign law, meaning a foreign state-made law, be it of a statutory nature or being of a common law nature, but has to be the law of a legal system that is given enforceability through the power of the state. That is a fundamental difference between addressing disputes in arbitration and disputes before domestic courts. And this is also clearly excluded the possibility of choice of non-state law in the Rome Convention on the law applicable to contractual obligations that became later on also the Rome on regulation of the European Union. Now, much the same way as the parties can choose the application of the CISG under certain circumstances, they can, and this is even explicitly said in the CISG, they can exclude the application of the convention under Article 6. They can exclude it, or they can derogate or vary from any of its provisions. What does that mean more concretely in detail? To exclude means to exclude in its entirety. You write in the contract, the United Nations Convention on Contract for International Sale of Goods does not apply to this contract. Or you write, this contract shall be governed by the laws of the state of New York with the exclusion of the United Nations Convention on Contract for the International Sale of Goods. So that's a complete exclusion of the CISG. But you may also derogate in part, saying Article 55 or 69 of the CISG does not apply to this contract. Or you may vary from any of the provisions of the CISG simply by providing otherwise in your contract, right? The only thing you cannot derogate from under the CISG is for those countries that under Article 95 require the contract to be entered in written form. That you cannot derogate from under the CISG. That's the only element that is of mandatory application. You can exclude it either by an express exclusion in your contract, or more often, this happens through an appropriate clause in your general conditions of contract. That's where most instances of exclusion of the CISG can be found in practice. That, and you have towards the end of the general conditions, there will be jurisdiction and applicable law, and that will be said, this contract shall be governed by German law with the exclusion of the United Nations Convention on International Sale of Goods. What is important, however, to note is that if a party intends to exclude the CISG, it must be explicit. Simply saying this contract shall be governed by German law does not exclude the CISG, because the CISG is an integral part of German law. The same for any other contracting state. And these courts have decided in many cases that when the parties simply say this contract is governed by Italian law does not exclude the CISG. So an intention to exclude the CISG must be explicitly stated in the contract. Now, moving now closer to the material scope of application of the CISG. What is excluded from the notion of goods governed by the CISG? First of all, what we would today call consumer transactions, right? the CISG does not use the word consumer, because internationally it's very difficult to find a common agreement of what a consumer means. For example, in some countries, consumer can only be a natural person. Some countries would also include small companies as consumers. In some countries, a consumer is defined as someone who acts in a non-professional way or a non-regular way. In other countries, a consumer is defined as someone who purchases a good or a service and extracts it from the market. So there are various different definitions. So the CISG doesn't use that expression. It talks about goods that are bought for personal, family, or household purposes. So if it's for any of these purposes, then it's not covered by the CISG. Unless the consumer nature of one of the parties was not apparent to the other, and the other party neither knew or ought to have known that the buyer in that particular case was buying for personal, family, or household purpose. The second big exclusion is goods sold by auction. And here the rationale is that auctions are in most legal systems subject to special conditions. Auctions in some legal systems exclude the application of some warranties that are provided under the CISG to sales by auctions. Many of them are conducted by the order of a court, and therefore it was found inappropriate under the CISG to have them covered by the convention. And that is also the exclusion under C. Under D, we exclude stocks, shares, investment securities, and negotiable instruments or money. Under E, we exclude ships, vessels, hovercraft, and aircraft, and F, we exclude electricity. Why are stocks and negotiable instruments excluded? Because in most legal systems, they are not themselves tangible goods. They may be, the holder may benefit from some sort of possessory protection, but they are in most legal systems regarded as documents that embody immaterial rights, the rights to participate in the shares of a corporation, or to vote in a corporation and a stock, or the right to receive a sum of money under a promissory note or a letter of exchange. So for that reason, they are also excluded from the CISG, and also because most of them are subject to specific procedures and formalities for being transferred. For example, a letter of exchange that needs to be endorsed in the back, a stock needs to be registered in the books of the corporation, etc. So they are excluded from the application of the CISG. Now, ships, vessels, hovercrafts, aircrafts is because not only their transfer in most legal systems is subject also to registration formalities. They have to be transferred in a registry, but also because most legal systems treat them as immovable goods. It's a legal fiction, but they're treated as if they were immovable goods. So that's why you have mortgages on aircraft and mortgages on ship, which you typically don't have on movable goods. You pledge movable goods, but you mortgage an aircraft. And that's also closely related to the registry system, but also to the flag system. Aircraft and ships bear the flag of a country. There are nationality concerns involved, and that's why they're all excluded from the CISG. And the last one is electricity. Even though nowadays, with the size of the international electricity market, some countries regret that the electricity is excluded, but it was excluded back then because electricity is intangible. It was not considered to be, it was not even in fluid state, and that's why the CISG expressly excluded electricity from its scope of application. Now, we saw what is the main scope of application, sale of goods. We saw what is the general understanding of goods under the CISG. We saw which particular transactions the CISG express excludes. Now it comes to a so-called gray zone contracts. And they include various agreements that are very common. For example, distribution or framework agreements. Distribution agreement is agreement, for example, between an automobile manufacturer and all those retail sellers that sell that automobile in their stores, right? So you have basically a framework agreement that sets the conditions under which they are sold. For instance, things, how your shop must look like, and other types of requirements of that nature, but also your pricing policy, et cetera, et cetera. Now, these agreements embody a large number of obligations that are unrelated to the delivery of goods. They are related to the relationship between these two corporations. And that's why that agreement itself, distributorship, is not covered by the CISG. That does not mean, however, that the CISG cannot cover individual purchases under a distributorship agreement. That is well possible if the parties do not exclude. So the individual purchases could be covered by the CISG, but the parent agreement itself would not. Franchising is another type of contract that is not covered by the CISG. Franchise is not covered by the CISG for even stronger reason, because the so-called immaterial and intellectual property components of franchising in terms of brand and trademark, etc., are even greater than the distributorship agreement. Every time you pass by a McDonald's, that should be obvious to you. They must look alike everywhere. The menu must be the same, etc. And the sales component there is minimal. And maybe there is no sales at all between the individual shop and the parent company with which that there is a franchise was negotiated, the franchisor. So franchise is also excluded from the CISG. There is still a big discussion as to whether the CISG covers barter transactions. Barter being the exchange of goods for goods. In favor of that, it has been said that most legal systems, in particular continental Europe, would treat barter as a subset of sales. And basically, you have extensive provisions on the contract of sales, and later on there's a chapter on the barter contract in your civil code that would say the previous provisions apply except as follows. And we have very few deviations for barter contracts. So many, at least in the early days of the CISG, said there is no logical reason why barter should be excluded. The opposing view, which seems to prevail, is that the CISG was built in the strong paradigm of exchange of goods for money, for currency. And when you look at the remedies for breach by the buyer, you see that those remedies assume that the performance by the buyer is a performance in money, is not a performance in goods. And the remedies were not conceived for failed delivery of goods. They could perhaps be applied, but that would require a certain exercise of interpretation. So barter transactions are not governed by the CISG. The last one that is important to highlight are turnkey contracts. A turnkey contract is a contract for the construction and installation of typically of an industrial plant. And it's called turnkey because the seller, so to speak, has an obligation to deliver, install, test, and commission a plant that must be ready by the time the quote-unquote buyer takes it over, so that the buyer only turns the key and the installation is running. So there is a significant element of delivery of goods there, right? Because its entire installation is being delivered. However, it's considered that the service part of that contract is also so significant that would not justify it being covered by the CISG, especially because in case of breach or unsatisfactory performance, not all the remedies of the CISG would be ideally suited for dealing and addressing and providing adequate remedies for the buyer in case of insufficient performance. That gets us naturally to the next point in Article 3. And these are the so-called mixed contracts. What when you have a contract that involves both sale or delivery of goods as well as services under the CISG? And Article 3 says the contract for supplies of goods to be manufactured or produced are to be considered sales unless the party who ordered the goods supplies a substantial part of the materials necessary for such manufacture or production. So that's the general principle. Under 3.2, the convention excludes, however, contracts in which the preponderant part of the obligation of the party who furnished the goods consists in the supply of labor or other services. Now we see in detail what is meant by these provisions. Now, if I order goods from a seller or hire a seller to manufacture goods for me, and I provide part of that, that is not by itself excluded from the CISG, as long as the preponderant part of that contract, of the goods that are being provided by the seller itself. For instance, if all the buyer commissions a line of cars, for instance, right? And with a special fitting, say that the roof would be a special roof that bears the emblem of that company, right? But that's the only material that's being provided. That contract is a contract of sales, right? And the fact that the seller had to first manufacture the goods and then sell them is irrelevant, because the manufacturer will be doing that anyway. And whether he's doing that, the manufacturer is doing that at your order or in the regular course of business is irrelevant for the CISG. By the same token, is also irrelevant for the CISG if the seller has to install or dismantle goods in order to perform the contract. Say, the company that installed the seats in this conference room, right? And sold them to the law school, performed a sales contract, and the fact that they had to physically install the chairs in this conference room does not make that a contract other than a sale of goods, right? By the same token, if you first have to remove the existing seatings and then install this, that will not change the nature of the contract, would still be a contract under the CISG. Now, if we have a mix of services and goods being provided by the seller in the contract, then the rule of the CISG, as you saw in Article 3.2, is that the CISG will govern as long as the goods are the preponderant part of the contract. Now, what does that mean, preponderant? And the CISG would not give you a clear-cut answer to that. You have to look into the circumstances of every particular case. What is the preponderant obligation? The preponderant value. Because what matters here is the value as a proportion of the total value of the good that is being delivered. By a rule of thumb, we would say that normally if the value of the services exceeds 50% of the value of the final value of the goods, this would not be a sales contract. But that would also depend in particular circumstances of the contract, what is the more important element for the parties. But what is essential is also to bear in mind that this determination is made as of at the time of the conclusion of the contract, not afterwards. So meaning a party is bringing services or know-how or intellectual property and material goods. And in order to determine whether that contract of sales or a contract of services or other type of contract, you have to determine the respective value of those things at the time of the conclusion of the contract. Because if you were to use a later point in time, then maybe that the goods would have acquired an even greater value because of the combination of those elements, and your perspective would have been distorted. It has also to be at the point in time that would, from which you can at least assume that would have been foreseeable for the parties as of that point in time, whether the CISG would apply or not. And if you leave it for a later moment, then the respective value of those things would change. An intellectual property component that makes the value of a good in a particular circumstance quadruple because 3 months after there is a big demand for that project in the market. But at the time of the conclusion of the contract, the value of that license was minimal because there was no demand of that good, so the parties didn't anticipate that there would be such a shift in the respective proportions. That should not be considered as to determine that that contract was not a contract of sale. So the moment has to be the moment of contract formation. One last important element is the supply of intellectual work. Obviously, if you are supplying work only of an intellectual nature, I think here you give the example of, say, a market study. The fact that that is delivered to you in a tangible medium doesn't make that a sales contract, because what is actually being bought are ideas. What is actually being bought is a service. So it's not a tangible good. There's a big discussion in literature about software, a discussion that has become a little bit dated nowadays, because nowadays software is in most cases being streamed over the internet under licenses. So I don't know, many people nowadays still buy a software on a hard disk somewhere. It's basically disappearing. But in the 80s and 90s, there was a big discussion, and there was in the 90s, at the beginning of this century, also many case law on the issue of whether or not the sale of software can come under the CISG. And most courts tended to say yes, as long as it is delivered on a tangible medium. But then what you're buying is actually not really buying the software as such, because the moment you open that CD, there will be a license that would apply to rights to use. So actually there's a bundle of rights. You will have the right to possess the tangible medium, and for instance, if the software is not working, you would have remedies under the CISG against the company that sold you that tangible medium to you, but you have a separate line of relationship to the company that designed the software. As I said, this is becoming dated nowadays because less and less this type of goods are delivered on the tangible mediums. They're being streamed online, so purely virtually. So there is no delivery of a good, so to speak, under the CISG. And because most of these contracts very clearly describe themselves as license agreements, and thereby excluding the application of sales law. Now, moving to the legal scope of application of the CISG. We saw the types of goods it covers, the types of contracts it covers, and now within the ambit of a contract of sales governed by the CISG, there are elements that the CISG itself will not govern, and they are listed in Article 4. So the CISG deals and governs the rights and obligations of the parties arising from the contract. However, it does not govern two important things. One is the validity of a contract, and the second is the effect that the contract of sale has on the property of the goods being sold. Under validity, we mean elements such as the capacity to enter a contract, or the illegality affecting the contract, the effects of mistake, duress, and fraud, misrepresentation and negligence, but also the effects of using an agent to conclude a contract. And very often the question, has the agent acted within hers or his powers as an agent, or has the agent exceeded the powers, and is then the principal bound or not bound by that contract? These are things that are subject to such extensive deviations and divergence under domestic law that it would have been completely unrealistic from the point of view of the drafters of the CISG to try to harmonize this internationally. Just to give you a few examples, beginning with the easiest one, capacity to contract. As how old do you have to be to enter into a valid contract? It can be 16 years here, can be 18 years there, can be 21 years in another country. Or other things that perhaps are nowadays are fairly unpopular around the world but still exist. Can you, as a married wife, enter into a sales contract? There are countries in which this is still not possible. So all these are things that are subject to strong domestic law notions of fairness or ethics and morality, and that's why they are excluded from the CISG. What happens if they are excluded from the CISG? Then you have to, if you are litigating in front of an Estonian court, the Estonian court, you have to look into its law, private international law, to determine which law would govern the capacity of the parties or the effects of illegality on the validity of the contract. But all the other aspects will be governed by the CISG. Another example is misrepresentation. If I negotiate a contract in bad faith and I'm concealing information from the other party, or perhaps I'm even passing inaccurate information to the other party, or I break off negotiations in bad faith, this is also treated very differently among legal systems. Continental European legal systems, for instance, tend to attach liability for breach of negotiations in bad faith. This is not the case in common law legal systems, where there is no pre-contractual duty of good faith, especially duty to negotiate in good faith. So, and these are not things that where any agreement would have been easy to find, and they're excluded from the CISG. Agency is the same thing. To what extent is the principal bound? If the agent has exceeded the powers, does that has to be known by the third party or not known by the third party? Does it have to be made to have been disclosed to the third party the extent of powers of attorney? Could the third party rely on the appearance of the agent having the power to enter the contract? So all these are points on which there is a wide divergence under domestic law, so they remain covered by domestic law. Then the other important point, transfer of property. You may wonder, what is the point of having a uniform global law for contract of sales if it does not cover the main consequence of a contract of sale, which is the obligation of the seller to transfer property to the goods, right? And may sound like a valid question, at least from a theoretical point of view. Again, here, there are pragmatic and practical reasons for this having been excluded from the CISG. And you see them in the slides. Just to give the examples of the continental European system, you have two very widely divergent systems for passing title to goods. You have the so-called consensual system, which is the system still in force in France and countries that were influenced by French law, whereby the contract of sales by itself transfers property to the goods. So I sell the goods and the goods already belong to the buyer by virtue of the contract. And then you have the so-called transfer by delivery under the German system, but it's not only Germany. Many countries apply the same system. Austria is in a bit of a modified form, but also applies. But also countries outside of Europe, many countries also in Latin America follow this system, whereby in addition to the contract, the law requires the effective physical delivery of the goods for transfer to pass from the seller to the buyer. Now, and common law systems may be somewhere in between, because you'd be looking at what is the intention of the parties, at which point in time the parties intended the property to pass from the one to the other. So these are fundamental differences, and that are so deeply rooted in domestic legal systems that the drafters of the CSG came to the conclusion that it would be useless to try to unify them in the convention. So this is excluded, but you see that the CSG found a way of getting around this question for what is really important, and that is the way the CSG deals with the passage of risks concerning loss or damage to the goods as they are transmitted from the seller to the buyer. So these are the central exclusions from that point of view. Apart from that, the CISG also does not cover the liability of the seller for death or personal injury caused by goods to any person. That is, in other words, product liability. So if the goods sold by the seller are defective or harmful and may in any way cause personal injury to someone, perhaps because they explode in a warehouse somewhere and damage property adjacent to it, or even kill people around it, that claims, the claims for injury, are as such outside, not governed by the CISG. There is, however, some debate as to whether the CISG would cover a redress claim by the buyer against the seller for the damage that the buyer had to pay. And that is generally considered that by virtue of the principle of complete indemnification for damages, that is an underlying principle of the CISG. So the CISG gives each party the right to full compensation in case of the breach by the other party causes damage. It is considered that if the buyer has to pay damage to a third party as a result of injury caused by defective goods supplied by the seller, that the buyer should have, under the CISG, the right to claim damages from the seller. There is no unanimity on this yet, but this seems to be nowadays the prevailing interpretation under CISG. Where there is no doubt, however, is that if the goods supplied by the seller cause physical damage to property of the buyer, then obviously this is covered under damage by the CISG. An example would be a purchase of commodity that is contaminated and it is then that commodity is, say, grain, for example, and that grain is then commingled by the buyer with other grain or coffee beans or any product of that nature, and they are contaminated and thereby contaminate the rest of the grain or coffee owned by the buyer. So that physical damage done to the other goods would also be covered by the CISG. Let's now move to rules of interpretation. So basically your question was, are there any ideas for including software or other intangible goods under the CISG, and whether having them excluded from the CISG would still be appropriate nowadays? I would say that probably legal certainty internationally would benefit from the existence of a framework instrument worldwide that will also cover transactions on intangibles, including software and other intangibles. That said, from a point of view of practical feasibility, I would regard that as highly unlikely that there would be any international agreement anytime soon for harmonizing the law that governs that type of transactions. It begins already with this point of whether this is a sale or is a license. And here we have opposing interests. The purchaser would prefer this to be treated as a contract of sales, of course, because you would like to own that product and be able to use and dispose of it. Now, the software manufacturer has an entirely opposite interest. The software manufacturer wants to be with entire control of that good and actually be able to access and monitor your use of it. And you know that that happens every day with every update of any software that you download on your phones or computers. They all come also with a license agreement, it's packaged as license. So this is commercially not an easy field, because you have already the significant opposition between two parties, and then from a practical point of view, any international negotiation would be very difficult, because the home countries of that industry would not favor a regime that would then displace their standard contract clauses of those corporations. So that is why you are unlikely to have any regime of that. And even if you look at the intellectual property regime nowadays, there are several conventions governing intellectual property rights. They are not concerned with the rights between the licensor and the licensee. They are concerned with the protection, vis-a-vis third parties, or protection against infringement of those rights, but not with the mutual obligation of the parties to the contract. So that typically will not be covered. Any other question? Yes, please.
Would the CISG also be applicable to lease agreements that have purchase options in them? Because we addressed that certain framework agreements, framework contracts are not subject to the CISG provisions, but lease agreements, at least in Austrian domestic law, sometimes understood as buyer's contracts, if there is a purchase option within them, or they're at least from a content standpoint quite similar to buyer's contracts.
The question is whether a lease agreement with a purchase option would be covered by the CISG, which is the case in some legal systems. The answer to this under the CISG would be, again, if this is part of one package, you'd have to value the performances at the time of the negotiation of the contract. And depending on the length of the lease and the lease rate, you might or might not considered that it could be covered by the CISG. But it was, in principle, the CISG was not conceived for covering lease agreements. That's not what the CISG was meant for. But if you have a purchase option, at least the sale part of it would be covered. And the question is whether the preceding part of that, if cannot be separated, then can be considered as being ancillary to the sale, and that could be covered under CISG, even though most of the remedies that would apply would not necessarily be the same and will not necessarily be appropriate. Okay? You have another question? Okay. There are two parts to this question. The first one, and I have here to make that clear, consideration is a particular notion of the common law, which is, apart from old renditions of French law, is largely unknown in civil law. And civil law does not make consideration as a condition for the validity of the contract. Obviously, it belongs to the fundamental notion of a contract that you have an exchange, right? But under civil law, you can also have promises that are enforceable without a consideration. That is common in civil law. So consideration is irrelevant for the CISG, absolutely irrelevant. And this is one case where you could not even say, for a contract governed by the CISG, that you have to control or check for the existence of consideration from the point of view of the validity of the contract. So there is no escape from the CISG on that point, because the CISG governs the entirety of the contract. And for the CISG, a contract is valid even without consideration. If I give you a penny for the goods, they're still covered by the CISG. Now, if I'm paying you only a penny for the installation and much more for the goods because I want it to be covered by the CISG, then is a factual question whether that is indeed the value. If the parties have agreed to that, then that's it. And then the CISG would govern that contract, regardless of the amount and the proportion of the consideration, so to speak.
Would you mind explaining
The notion behind consideration is that under common law legal systems, a promise to do something that is not made in exchange for a performance by the other party is not enforceable by law. Like the courts will not enforce that. So a unilateral promise is not possible. That's why in the UK, until the 20th century, you could not enter a contract to the benefit of the third party, because the third party would not be able to enforce that contract against you for lack of consideration. The promisor would say, I haven't gotten anything from you. You have no title to seek judicial enforcement of this promise against me. This is basically an unenforceable promise. You may have remedies under equity, but that's a different story, and that you get into a very complicated aspect of UK law. But that's the basic notion. Under civil law, contracts also in principle are synalagmatic exchanges. A quid pro quo, right? You give something for something. But civil law has for a very long time accepted you can also enforce unilateral promises. And that's Now, under the common law, consideration still plays a very great importance under the law, because you can use as a defense against enforcement of a contract the argument that there has been no consideration. Now, that said, also in practice, you find hundreds of cases in the United States where $1 payment was considered enough consideration. So these things are no longer as, how can I put it, apply as dogmatically as they are. But the notion of consideration exists. And this is why one of the reasons why under common law, just to close this parenthesis, there is no pre-contractual obligation for breach of negotiations, even if it's in bad faith, because until you sign a contract or until there's a meeting of minds, there has been no consideration, so you cannot be bound by something that doesn't exist yet, right? And that is also, again, fundamentally different from civil law, where we consider that you have a duty of behavior that is enforceable against you, even in the absence of an existing binding contract. That is by itself offensive to the common law legal mind. It is even more offensive for you to be bound before a contract if you haven't received anything for it anyway. So this is what is behind this notion of consideration. Okay? I think there was one more question there. No? Okay. Then. Well, there are instruments that govern particular types of, there are conventions on nuclear damage, there are conventions or damage done by specific means of transportation. There is a lot in terms of international instruments there. There is nothing generic about product liability. This is something that at a certain point was even discussed at UNIDROIT in Rome back in the 80s. After that big accident in India, Bhopal, where one big factory exploded and thousands of people died, and there was a vast contamination of the environment. But there has never been a consensus international to develop an instrument governing product liability. There is a directive within the European Union that governs product liability, but at the global level, there is nothing. Okay? Now, shall we move on now to the next topic, and that is interpretation. And the CISG contains provisions on interpretation at two levels: the interpretation of the convention itself and the interpretation of the contract. Okay? And you'll be looking at them separately. The rules of the interpretation of the convention say that in the interpretation of the CISG, the interpreter has to bear in mind the international character of the CISG and the need to promote uniformity in its application and the observance of good faith in international trade. These are the general things that an interpreter has to bear in mind. And then the second provision, 7.2, provides rules for interpretation in cases that are not governed by the CISG, or cases that are governed by the CISG but that are not expressly settled under the CISG, which are to be ruled by the general principles underlying the CISG, and if there are no such general principles, by the applicable law, by virtue of the rules of private international law. And we'll see now what that means in practice. The CISG is an international treaty, right? There is a treaty, and coincidentally is another Vienna Treaty, the Vienna Convention on the Law of Treaties, that sets rules for the interpretation of treaties. Right? This is why it was felt important in the CISG to write specific rules, because the nature of the CISG is particular, is peculiar, is not identical with the other treaties governed by the Vienna Convention. Why? Because those are typically treaties that provide for obligations between states, states-to-state obligations, right? Say, the Brexit, right? The Brexit would be an agreement between the Union, the 27, and the United Kingdom on the condition for the exit of the United Kingdom. And these creates rights and obligations between them. Of course, there will be impacts on citizens and others, but primarily between the parties to the treaty. Or a boundary treaty, say the treaty between Austria and Italy concerning the mutual borders. This creates obligations to the two states. And for that, the Vienna Convention has a certain number of rules how are they to be interpreted. Among those rules, that the subsequent practice of the parties is important to interpret the treaty, etc. Now, the CISG is meant to apply to private transactions. It's not primarily conceived for regulating relations between governments, but between private citizens, and it's to be applied by judges and arbitrators. And here, the most important thing is what? To ensure uniformity, to ensure that it is understood in all countries in the same way, because otherwise, there would have been no point in developing an international treaty if after 10 years the French courts read it one way and the German courts read it another way, the Chinese and the Japanese in yet another way. So the CISG invites the judge and the arbitrator to avoid the so-called homeward trend, that is to open the CISG and say, I don't understand this provision. How do we regulate this in the German Civil Code? This is not how the CISG should be interpreted. What the German court should do is, how have other courts around the world interpreted this provision? What do the commentaries of the CISG say about this understanding of this provision? That is to promote uniformity in the interpretation. That's what should be in mind, in the minds of the interpreter. And also, when looking at a term in the CISG, not to interpret a term necessarily the way you interpret it under your domestic law. Apart from the fact that the CISG tries as much as possible not to use any technical expression that has a very typical connotation in any particular legal systems. You see, we use in the CISG a neutral language to avoid that. Yes, please. She's asking whether there is an organ competent to interpret the CISG, and the answer is no. The answer is no, and also that there is no plan to establish such a thing, because that organ would have to be a world court of commercial contracts. And there is no interest so far in the international community to subjecting their own courts and judiciary system to the interpretative authority of a world body. The citizens of the European Union who live in a particular, very unique environment where we have a court that interprets the EU treaties and that is binding to all 28 EU states. If you move outside Europe, you are living in the pre-war system of sovereign nations that are completely independent from one another and that are not subject to this kind of centralized governmental structures. So there is no court, and that is what makes this process a particularly difficult one. That's also why we at UNCITRAL invest so much time in producing information materials, disseminating court decisions, publishing them in 6 languages so to facilitate access by courts to foreign judicial decisions to try to promote some level of uniformity. But it's an appeal that the convention makes to courts to bear that in mind, but is not enforceable. Okay? Now, and then the other principle for interpretation of the CISG is the observance of good faith in international trade. Now, this should not scare the common lawyers. That doesn't mean that the CISG creates an overall obligation of good faith, which common law systems resist acknowledging as a general rule. There are several specific duties of coming out of principles such as reliance or estoppel or other principles under common law that are intended to achieve a similar result in terms of equity and fairness in relations, but there is no overall duty to act in good faith under the common law. There is no such a duty under the CISG either. So the CISG, what it provides, it has specific duties that in a specific context may come close to something like that, but you cannot transform that into a general principle of good faith that doesn't exist. That said, this, when interpreting the CISG, a judge is called upon to consider, in deciding this case, which decision would best promote good faith and best sanction unfair behavior in international trade. Okay? But that is how far the CISG gets on that particular point. Now, let's now come to gap filling under the CISG. That is paragraph 2 of Article 7. How do you fill gaps? And here you have to bear in mind one important distinction under the CISG. And that is the distinction between internal gaps and external gaps. An internal gap on the CISG is a matter that is covered by the CISG, but the final answer is not there. So the CISG does not give you the full treatment of that question. For example, that's a classical example, interest rates. The CISG says that the seller, in case of breach by the buyer to pay the price for the goods, one of the remedies of the CISG is interest. So the other party, in this case the seller, would have rights to interest. Now the CISG doesn't tell you what is the interest rate. But it is considered that this has to be decided within the ambit of the CISG. You don't need to look for otherwise applicable law. The same thing, the currency of payment. The CISG provides for the buyer's obligation to pay the price. It doesn't tell you which currency that price must be paid. It's typically stipulated by the parties in the contract, but in case it is not, then it has to be addressed under the CISG, and you don't need to look for domestic law for that. The CISG would provide you with an answer. But then within this ambit, things that are covered by the CISG, not fully addressed by the CISG, then how do you fill this gap? Then you have recourse to the general principles underlying the CISG. Now, you read the entire CISG, you will not find one article that says these are the general principles underlying the CISG. They are derived from interpretation of the text. And here I give you a list. Some people found many more principles. These are the, so to speak, the less contentious ones, those on which there is greater agreement that they are principles underlying the CISG. Party autonomy and freedom of form. So the CISG respects the rights of the parties to shape their contract according to their needs, so they're free to negotiate whatever bargain they want, and the CISG does not impose limits to that. You can derogate from the entire CISG. Party autonomy, so it's one of the general principles of the CISG. Freedom of form is the same. The CISG does not require your exchanges or communications to be recorded in any particular way. You're free to do that whatever way you want. Observance of good faith in international trade. Yes, that in interpreting the CISG, you should always prefer the solution that would not promote unfair behavior in contractual sales transactions. Estoppel. For those of you who are not familiar with this term, which comes from the common law terminology, and again, the CISG does not use this term. It's not written there anywhere. Estoppel, the principle that, and in continental European systems, we use a Latin phrase for that, non venire contra factum proprium. That's basically, it essentially means the same. There's the notion that if you, by your conduct, lead the other party to the contract to believe that something will happen or that you will perform the contract in a particular way, and the other party, that's the consideration aspect of the estoppel, and the other party take some action to its own detriment on the assumption that you will behave the way you led that party to believe that you'd behave, you can no longer walk back on your conduct and behave otherwise, or you have to pay damages for the cost and the damage caused to the party that acted in reliance on your representations of that party. And this is also an underlying principle of the CISG, that you, by your conduct, may lead the other party to take some action, and that you may no longer be free to act otherwise without engaging your liability to pay damages to the other party. Then the principle of preservation of contract. And that you'll see various examples when you talk about that, when you talk about remedies under the CISG in case of a breach by either party. Many legal systems make it relatively simple for a party to a sales contract to walk away from the contract, terminate the contract, in particular civil law legal systems. The CISG does not make it that difficult. The CISG has an overall tendency to preserve the contract as much as possible and do not make it too simple for the party simply to terminate the contract. That has many reasons, but one of, not only because there was an interest in accommodating differences between legal systems, in this case, the common law system, but not only, and the Southern European Romanic systems that make termination easier. Not only that aspect, but also because the CISG was drafted for circumstances peculiar to the international trade. And there comes the entire logistic that is required to perform a sales contract, which will be part of this lectures. There is a transport contracts, and there is a letter of credit or documentary credit contract that are both necessary to support the performance of the contract. The contract may also need various other ancillary obligations to be performed. You may need insurance for the goods. You would need the warehousing of the goods. There will be customs clearance. There are several other measures that must be taken, which make an international sales contract fundamentally different from simply going with a truck to a factory, buying goods and loading a truck and bringing them to your place of business. And that's why the drafters of the CISG bear in mind the costs and time associated with undoing a contract. Conceived a system that engages the parties to preserve the relationship as much as possible. And we see, when we look at breaches and remedies, how that's concretely structured under the CISG. But then also the principle of full compensation of damages. The only criteria for limitation of damages under the CISG is the notion of foreseeability of damages. At a certain point in time, we'll see that when we get to the an examination of the provisions concerning breach and remedies under the CISG. But in principle, all damages caused by breach of contract are recoverable under the CISG. Then that is also then compounded by an obligation under the CISG for both parties to mitigate their damages. If at one hand I have the right to be fully compensated for the damage that I have sustained, I also have an obligation under the CISG to limit that damage. For example, if the seller has delivered perishable goods that are either different from the goods that I order or of a different quality, I cannot simply terminate the contract for lack of performance and let the goods perish. I have an obligation under the CISG to sell those goods or to place them in a storage to avoid them from to prevent them from perishing, and thereby reduce the damage that I will sustain and also reduce the damage that the other party would be obliged to pay me for the breach of contract. So it's also related to the notion of preservation of contract, but as a pendant to the principle of full compensation of damages under the CISG. So all these are principles that will be used and should be used by the interpreter when filling a gap under the CISG. Now, but if I cannot find a principle, or if a matter is completely outside the CISG, then I have to resort to the otherwise applicable law. And for instance, validity is, as an example, as you know, because it's expressly excluded by the CISG, right? But apart from that, everything that is covered by the CISG, if there is no immediate answer in the CISG, has to be answered in accordance with the principles that govern the CISG. Have questions on this part? Yes, please.
You mentioned the duty to mitigate.
Yes.
And I just wondered if this is compatible with termination. So in some cases, the seller might have the duty to resell to another buyer to mitigate the loss.
Mm-hmm.
But then would termination be available, or would this exclude each other?
No, they are not mutually exclusive. Obviously, there is a standard of reasonability also in the measures that either party is obliged to take under the CISG to mitigate loss. A party is not obliged to incur excessive cost or unreasonable cost only to mitigate loss. It has to be within a certain standard of reliability. And the party would have an obligation to mitigate loss even if it has the right to terminate the contract. So for instance, in the case of the perishable goods, I give notice to the seller, I intend to terminate the contract. You delivered something that is not what I ordered. but I must sell or place them on some storage to avoid them from perishing. So the two things can go together depending on the circumstances. Sure. Yes, please.
In case if these goods are not perishable, just normal goods, so what should the buyer do? Because if I'm not mistaken, according to CISG, it is possible to reject the receiving of the products in case of violation of the contract, in breach of contract. So if I see that these products, the quality of these products is not fulfill the requirements of the contract, what should I do as a buyer?
Can you wait 1 hour and then we'll be discussing that later?
Yes.
Yeah, later today when you get to the obligation of the parties and the duty of conformity. And then when we get to also the remedies, we'll also be discussing that. Yes, please.
You talked about the interest rates and that it's not defined in the CISG how high it is. Can you give us a specific figure on how high it is regarding to case law?
You'll find all the case law, also expressed case law on interest rates in the digest. I don't have a figure in my, that I can give to you. But they range from countries, there are decisions that would apply the average interest rate of the country of the place of payment, to other countries that would apply a statutory interest rate for those that use the applicable law to solve that question, to those that would apply the average interest rate in the place of the seller. So these are basically the parameters. Basically, the choice that courts and arbitral tribunals make when looking at interest rates is whether they would look for a statutory interest rates that is specifically provided for late payment, or whether they will be using commercial interest rates. And for instance, the UNCITRAL principles of international commercial contracts advocate the use of the average rate that is obtainable in the place of payment, right? But there is the actual figure of the percentage of interest rates would vary according to the system that the court or tribunal will be applying. Okay? Okay, if no more questions, then at least we now like to start on contract formation under the CISG. And this involves both the process of formation of the contract and the process of interpreting a contract under the CISG. And the provision of contract interpretation are not exactly the same as the provision on the interpretation of the CISG itself. The CISG follows a fairly classical approach to contract formation between absentees, so parties that are not on the same place at the same time. So like in any legal systems, like contract exists when there is a meeting of minds, that is when an offer has been accepted, right? And the CISG considers that the offer is effective when it reaches the offeree, and the acceptance is accepted when it reaches the offeror. So it's the so-called reception theory, which is the prevailing theory under continental European law, that a manifestation of will becomes effective when it reaches the other party. It's not necessarily the rule prevailing under common law. And you see that there is a compromise between the two of them, you will see in a moment. The CISG also declares that an intention of the parties, that is an offer or a declaration, reaches the other party when it is delivered to the other party, or when it's orally made to the other party. And delivery meaning it has to reach, is not just the dispatch of that communication to the other party. So that doesn't mean, however, that the CISG would only apply to a contract that comes about by exchange of letters, because that would mean that the CISG probably apply to no contract whatsoever nowadays, because they're no longer made that way, right? It can also obviously also apply to a contract that comes about by exchange of electronic communications, by clicking on a website, because you always still have communications that are exchanged between the parties, right? And the fact that are instantaneous would not necessarily change that, because any computer technician would tell you that they're not really instantaneous. There's always maybe a minimal gap on a fraction of a second between one message and the other. What the CISG, however, does not cover, as I mentioned to you, is pre-contractual liability. So what happened during your contract negotiations and the breach of contract negotiations is completely outside the CISG. So there may be legal systems that would assign liability to that. That would be typically in continental Europe if you breach negotiations in bad faith. There would be some circumstances under US law whether that would be possible, and more seldom so under UK law. But under common law, there would have to have been reliance by the other party to that other party's detriment, and there you might have a claim in damages against the other party. But that's a very exceptional situation. Simply interrupting negotiations is not sanctioned by law that way. And this is also then not covered by the CISG. By the same way, because the CISG doesn't deal with validity, doesn't deal with the validity of contract terms, if they are considered to be unfair, for example, under the EU regulations on standard contract terms, or if they are considered to be unconscionable, to use a terminology of the common law systems, also that is not governed by the CISG. Also, the CISG does not cover, for purpose of contract formation, the effect, as is a practice in some countries such as Germany, that you reduce your contract negotiations to a writing and send that to the other party as a confirmation. And the fact that you don't react to that is maybe they're considered to be an acceptance of the contract. This is not covered by the CISG unless it is a trade custom in that country concerned. Now, so far so good. But what does the CISG require? An offer also has to meet certain requirements, and those requirements, in order for it to be validated, those are essentially that it has to express the intention of the party to be bound by the contract. This is obvious. So an offer that is only as an invitation for parties to bid is not considered to be a binding offer. And it has also to indicate the goods and implicitly or expressly fix or make provisions for fixing the price. Okay? And one that is addressed to more than one person is considered to be an invitation to make offers. Now, what does it mean to identify the goods? And here we see in practice that the courts interpret this fairly liberally in the light of the practices that the parties have established among themselves. So the examples I'm quoting here are all examples of case law, and are all compiled in the UNCITRAL digest on case law on the CISG. For example, 700 to 800 tons. we may consider that it's a big difference. 100 tons of whatever is a big quantity. But in that particular case, the court considered that it being a commodity of not a great value, and given the extent of previous dealings between the parties, that was considered to be within a range of reasonability, that variance, that would not render that contract invalid, because there was a course of dealing with partners say, you deliver how much you have, and I take how much you can offer. So even though the figure was not precise, there was still a valid contract. Another example was, 3 truckloads of eggs. Right? In that trade, people knew what that means. I mean, if you have 20 eggs more, 20 eggs less, that doesn't make a difference. And the court would still uphold that contract, even though they don't have a very precise figure. But, even an open-ended contract, and that's an interesting example, when it's a contract where the buyer ordered a greater number of chinchilla furs. That doesn't mean a greater number, right? But the court would look at the dealings with the partners, said this part, it's not, first of all, it's a rather expensive article. It's not something that you buy by the hundreds. You have a certain clientele, you have a certain practice or experience of selling so and so many per winter season. And a greater number meant for the seller, something more than last year, right? Something more than the last 3 years. And in this case, the seller delivered a little bit more than the buyer had expected. The buyer got stuck with the furs and then said, but there was no valid contract because the buyer was now not unable to resell them. And the court came to the conclusion, it was not unreasonably much more than what you normally had ordered from the seller. And the court concluded that it was a valid contract. The contract doesn't need to include all the terms, in particular not all of those for which the CISG itself provides default rules, right? For instance, quality of goods, place of delivery, period of delivery, mode of transportation, all of these are things for which the CISG provides a direct or indirect answer. However, certain things would always be considered to be material. For example, the settlement of disputes and other essential provisions of the contract. And as I said, a contract offered to a wider group of people is considered to be an invitation to make offers and not a firm offer. Now, so far so good, but then you move down to Article 55 of the CISG concerning the buyer's obligation to pay the price, and you find a provision that says, where a contract has been validly concluded but does not express or implicitly fix or make provisions for determining the price, the parties are considered, in the absence of any indication to the contrary, to have impliedly made reference to the price generally charged at the time of the conclusion of the contract for such goods, sold under comparable circumstances in the trade concerned. And you look at this and say, but how come? Didn't Article 14 require the contract to fix or make it possible to determine the price? And now Article 55 says, but you can't enter a contract without fixing the price. This Article 55 was the result of extensive deliberation at the Vienna Conference, trying to bridge the gap between two opposing views. You had some civil law systems, in particular France, where a contract must have a determined or determinable price, otherwise it is invalid. And other countries, some of the civil law families, such as Switzerland, but also common law countries that advocated for more flexibility. And then the result was this article, for which there are three basic interpretations. The liberal interpretation would say, Well, yes, Article 14 does require the contract, a price to be fixed or determinable, but the parties maybe wanted a contract anyway, and one of them even started performing the contract, so it is unreasonable now to invalidate the contract if the parties intended to be bound by it. The second, there's a more rigid interpretation, says no, Article 14 always prevails, and Article 55 is there only because countries, when ratifying the CISG, may have the choice to exclude the chapter on contract formation. So for those, then they exclude the chapter for confirmation, they have the rule in Article 55. But if you take both parts of the CISG, then 14 should always prevail. Then you have a third interpretation that says, well, this was actually meant to say, since validity is not governed by the CISG, that if your legal system allows you to enter into a contract without a price, then it's covered by Article 55. If it does not, then it goes for 14. Probably nowadays, the most widely held view is the liberal interpretation on the basis of the intention of the parties. That the court should look at what the parties intended with that contract, and it's particularly if they've started performance of the contract, then they wanted to be bound even though the price was open. And there are many trades in which this happens because there are daily quoted prices for those types of commodities or goods that the parties are buying, and the parties rely on the market price for that, and then they do not necessarily always quote the price in their contracts. And this is the more liberal understanding of this provision that is advocated nowadays. Now, one other aspect of contract formation that I would like to mention to you before we would then be moving to examining the obligation of the parties concerns the revocability of offer and acceptance. And this is again an area where there was a clash of legal cultures because the Scandinavian and Germanic legal systems tend to consider contract offers firm and irrevocable. And the common law and the Southern European Romanic legal systems tend to consider offers non-binding until they are accepted. And here the drafters of the CISG had to develop a compromise solution between the two systems. It begins by saying, and this will see, let's say, looks like a concession on the common law, but is not necessarily so, is that you can always withdraw an offer. Even if it's say this is an irrevocable offer, you can always withdraw it if the withdrawal reaches the offeree at the same time or before the offer, right? And I send you the offer by letter, then I pick up the phone and say, you'll be getting an offer, but disregard it, I'm withdrawing it, right? And then that offer is withdrawn. But that is withdrawal, that's relatively simple. The question is how you revoke an offer that has already reached the addressee. And then this CISG says it can be revoked if the revocation reaches the addressee before the addressee dispatches the reply. And this is a concession on the common law notion of contract formation, that dispatch theory. It can only, however, not be revoked if it indicates otherwise that it is irrevocable, or if it was reasonable for the offeree to rely on that offer and take action on that basis. So this is the basic construction of this issue under the CISG. So as you see, Article 16.2 reflects the principle of estoppel. It doesn't use it, but that's basically this notion behind it. Say, I can revoke, but if at that point in time the other party has already, for instance, hired transportation for the goods, or hired the service of phytosanitary control for those goods with a view to their exportation, or taken other action, then that revocation would no longer be possible, right? Simply for the civil lawyers to understand this reference here to the dispatch theory, that this is a very long established also doctrine in common law, that the acceptance of an offer becomes effective not when it reaches the offeror, but when it is dispatched by the offeree. Because at the end of the day, the question here is who bears the risk for loss of that communication, one party or the other, right? And the civil law system places the risk on the offeree, because my acceptance may get lost and then there was never a contract. And the common law system places the risk on the offeror. And I quote these cases, you can read on the slides, but in particular interesting, this case, Barr versus Shaw, that clearly states that it is not inconsistent with the contract philosophy of the common law that the contract would come about even if the offeror would have no knowledge of that. And that under the common law, that is a preferable situation than placing the risk entirely only on the offeree, who behind this notion is that the notion that the offeree, again, the stopper, would have already started doing what is necessary to perform under that contract. I would like to conclude the part on formation of the contract by making remarks on two important concepts under the CISG. Is that the article, under Article 18 of the CISG, silence is not a valid acceptance, and the CISG will not consider it sufficient in order to regard the contract having been formed. However, the practices established in between the parties and the actions of the parties may be sufficient to indicate that by conduct a party has accepted a contract. So the CISG does not always require the acceptance of the contract to be in the same form as the offer. It can also take the form also simply of conduct. Inactivity by itself is not sufficient, but it may be that the offeree by conduct would be indicating to the offeror that he has accepted the contract. And for instance, the buyers accepting the goods without immediately rejecting them, the buyer paying for the goods, or the seller cashing a check. There are various actions that in practice have been signaled by courts as being acts that indicate the acceptance of the contract by the offeree. Now, one last point that is important on contract formation before we turn to the obligations of the parties is the issue of conflicting terms. Obviously, if the reply to an offer contains terms that deviate from the offer, that's a new offer, and you start the game again. That has not been a valid acceptance. If it's a minor deviation, the contract is deemed to have been concluded with the non-conflicting terms, but deviations with relation to price, quantity, quality of goods, or dispute settlement, and other such fundamental points are considered to materially alter the offer and are not regarded as a valid acceptance. What about conflicting contract conditions? And that is what's most commonly happen in practice, that contracts are not negotiated word by letter, but a company attaches its general terms of sale and the other company attaches its general conditions for purchase, and they are inconsistent with one another. Here, this is the so-called battle form situation, and here we have basically two solutions. One of them is the knockout solution, that is, if the conditions are conflicting, the contract is deemed to have been concluded, including those conditions that match and excluding those that contradict one another, right? And the other being the so-called last shot theory. I send you my conditions of contract, you send me yours, and I reject yours and send mine back again, and this goes back and forth until one of them forgets or doesn't care anymore, and you consider that whoever sent the last batch of conditions prevails. There are arguments for both situations. In favor of the second situation, which some may say is arbitrary, you have the positive argument that this provides greater legal certainty because you know exactly which set governs. The other one is less arbitrary and allows you to identify better the common interests of the parties. However, it requires an ex post determination by a court of an arbitral tribunal of which conditions are compatible and which are inconsistent with one another. Sorry? I would say that the one that is currently most widely held to be the better solution under the CISG is the knockout rule. And it's also one that is familiar to most the more developed advanced systems of commercial law. You'll find that there's also an opinion of the CISG Advisory Council that favors that position. In the early days of the CISG, most commentators advocated for the last shot rule because the CISG did not provide an express solution for that. As I said, the CISG contemplates freedom of forms. We don't need to dwell on this. You can enter into a sales contract by whatever form, but the CISG would, however, recognize a contractual clause that limits contract amendments to amendments in written form, unless the parties, through their conduct, have shown that they are willing to dispense with that requirement. Written form for sales contracts are only mandatory in countries that made a reservation under 96 of the CISG. You have the list: Argentina, Armenia, Belarus, Chile, Paraguay, Russia, Ukraine, and Vietnam. And one important element of the CISG does not cover the so-called parole evidence rule. This is a rule in the common law that would not allow for the use of non-written information or statements or evidence against the plain text of a written contract. Parole evidence rule. And here, with that, we are in the realm of contract interpretation. And we know that here, too, there are substantive differences, at least in principle. In practice, the two systems come closer together between the civil law and the common law on the functions and methods for contract interpretation. Under civil law, the purpose of contract interpretation is, as you have stated in Article 8.1 of the CISG, to review the intent of the parties when they negotiated the contract, right? This is the main purpose of contract interpretation. The common law adopts an objective standard of contract interpretation. The common law says the function of contract interpretation is not to find out the subjective intention of the parties. A contract is a legal act that has to be understood within its own context in an objective meaning, and has to be understood the way a reasonable person in that situation would have understood those terms, without asking for the subjective intention of the parties. As you see, the CISG actually combines the two of them. It says in Article 8.1, it has to be interpreted according to intent of the parties, but in 8.2 says, when that is not available or is not possible to be determined, then it has to be in terms of the objective terms of the contract. Where it differs substantially from the common law, it would be in 8.3, because 8.3 clearly says you cannot use previous negotiations between the parties to establish the meaning of a contract term, in particular not if you try to deviate from what an objective reader would read into that provision. So it is a compromise, but it is a compromise that, say, does not give everything to, say, in this particular case, to the common law world, by admitting that you can bring other elements. The justification for this, for any common lawyer, should be that in international trade, contracts are seldom rendered and reduced to one single piece of paper in one document. They consist in most cases of extensive exchanges between the parties, of incomplete pieces of paper and phone calls establishing what the parties need. You have a seller here, a trader there, they send a purchase order, the order replies, calls on the phone that says, but I don't quite have this quality today, what about if I give you a substitute product? And the order say, yes, that's okay, but I intended it for this purpose, and is that okay? Can you deliver within that deadline? And you do not necessarily have one organic legal text that base your interpretation. And that's why the CISG acknowledges that when terms are ambiguous or unclear in the contract, one may resort to other sources of information in addition to what is only rendered into that particular piece of written information. Now, I would suggest that we pause now for, say, a short break of 5 minutes just to stretch our legs, and then we will continue. Thank you. We're now, for the obligations of the seller, we have a guest lecturer, Professor Hiroo Sono from the Hokkaido University in Japan. Professor Sono is a member of the Governing Council of UNCITRAL. He's also a member of the CISG Advisory Council. He has been advisor of the Japanese Minister of Justice and Japanese delegate in many international negotiations, including at UNCITRAL. Given the time difference, Professor Sono is not joining us live, but he was kind enough to send us a pre-recorded video on the obligation of the seller, which would then be playing now.
Good afternoon. My name is Hiroo Sono. I am professor of law at Hokkaido University in Japan. I trust that Angelo has just given me a nice introduction. I would like to thank Angelo for that, and also for inviting me to give a lecture on the obligations of the seller on this special occasion at the 40th anniversary of the CISG. My thanks also goes to UNCITRAL and to the University of Vienna for giving me this opportunity. Now let me share my slides. Okay. From here, this lecture series turns to part 3 of the CISG. Part 3 deals with the obligations of the seller and the buyer. Chapter 2 of part 3, just a second. Okay. Chapter 2 of part 3 deals with the obligations of the seller. The seller's obligations can be divided into 2 aspects. First, the seller must deliver the goods and also transfer the property rights in the goods. But that is not all. There is a second aspect. The goods that the seller delivers must conform to the contract. Under the CISG, the first aspect is dealt with in section 1, and the second aspect is dealt with in section 2 on conformity of the goods and third-party claims. Chapter 2 adopts a simple and easy to navigate structure of defining what the obligations of the party, what the obligations of the seller are in sections 1 and 2, and then goes on to provide what remedies are available to the buyer in case the seller is in breach of the contract in section 3. Chapter 3 on obligations of the buyer adopts, for that matter, adopts a very similar structure. This lecture, my lecture, deals with section 1 of chapter 2. The most basic provision on the obligation of the seller is Article 30. It provides that the seller must deliver the goods, hand over any documents relating to them, and transfer the property in the goods as required by the contract and this convention. So basically, there are 3 obligations for the seller. First is to deliver the goods. And as I said before, there are 2 aspects to this. The first is the actual delivery of the goods. The second is delivery of conforming goods, which means that the goods that the seller has delivered must conform to the contract. The second obligation is to hand over documents relating to the goods. And the third is transfer of the property in the goods. Can there be other obligations? Yes, the parties can agree on additional obligations under Article 6. For example, the seller of a machine may undertake an obligation to install the machine at the buyer's site, at the buyer's factory. Under Article 3, Paragraph 2 of the CISG applies to such contracts unless installation is the preponderant part of the seller's obligation. So there can be additional obligations, but the basic obligations of the seller are these 3 types of obligations. Now, as I said, there are 3 types. I will begin with the last one, transfer of the property in the goods. Transfer of property is an essential element of a sales contract. However, it is important to note that the CISG does not deal with the question of whether the property in the goods has in fact been transferred to the buyer. That is not a matter that is governed by the CISG. This point is clear from Article 4B of the CISG, which provides that which provides that the CISG is not concerned with the effect which the contract may have on the property in the goods sold. So this question, the answer to this question must be determined by reference to the law designated by the rules of private international law of the forum. So in other words, how and when a transfer of property occurs is not a question for the CISG. It is a question for the applicable domestic law. In some sales contracts, the seller retains a title to the goods in order to secure its right to payment of price. This is done by inserting a retention of title clause in the sales contract. Does this clause mean that the title of in the goods does not pass at all to the buyer until the price is paid? Or does this clause mean that the title passes to the buyer, but the seller retains a security interest in the goods? This is a question, again, that is left for the applicable domestic law, and the CISG does not govern this question. In jurisdictions that have compatible rules with the UNCITRAL model law on secured transactions, will consider it to be a security interest. It will consider that the retention of title clause creates a security interest, and the title and the property to the goods will pass to the buyer. But again, that is a matter for domestic law. So in short, the CISG provides that the seller has an obligation to transfer the property in the goods, but fulfillment of that obligation is determined according to other laws. Now I will move on to the next issue, the first obligation of the seller, delivery of the goods, and the actual delivery of the goods. The first question is the place, where, and how, the modality of delivery. The place and modality of the delivery is the first question, and Article 31 is the provision that we look at. This is a long provision, but to make it simple, it is helpful to make a distinction between international sale of goods. Let me turn to the next slide. International sale of goods involving carriage of goods, and those that do not. So here it's the first group is A, the second group is B. In international sale of goods involving carriage of the goods, delivery is done by the seller handing over the goods to the first carrier for transmission to the buyer. That is Article 31A. And here, handing over means giving actual possession of the goods. In other international sale of goods, the seller's delivery must be executed by placing the goods at the buyer's disposal at a certain place. Where this certain place is will depend upon whether it is Article 31B or 31C applies. And placing the goods at the buyer's disposal here means taking all necessary steps so that the buyer can collect, which is to take possession of the goods. So the seller must do everything that is necessary so that it will be only for the buyer to pick up the goods. That is placing the goods at the buyer's disposal. Now, this sale involving carriage of the goods are those where interplay between contract for the sale of goods and the contract for the carriage of the goods. These are two separate contracts, In this type of contract, in this type of sales, there will be an interplay between the sales contract and the contract for carriage. Now, as I said, we have to distinguish between these two types of transactions, these two types of contracts. Now, in order to make this distinction, we have to know what a contract of sale, international sale of goods involving carriage of goods means. This slide explains what a sale involving carriage of goods is. First, there must be an independent carrier that is engaged by the parties, seller or the buyer, to transport the goods. And this engagement must be based upon an agreement between the seller and the buyer. In other words, the contract of sale must anticipate this kind of engagement. That is the first condition. And in this kind of sale, in this kind of contract or contract of sale involving carriage of the goods, the seller is not obligated to deliver or transport the goods to the buyer's place of business. The seller can fulfill its obligation by handing over the goods to the carrier. That is the obligation of the seller in this kind of contract. The seller does not have to actually hand over the goods to the buyer. All it has to do is to hand over the goods to the carrier. And the buyer, in turn, will take over the goods from the carrier, not the seller, at the destination of the carriage. Now, if the seller undertakes to deliver the goods at the buyer's place of business and engages an independent carrier to deliver the goods to the buyer's place of business, that is not a sale involving carriage of the goods. Of course, carriage is involved in that contract, in the performance of that contract, but for the purpose of Article 31 or for the purpose of the CISG, that is not a contract of sale involving carriage of the goods, because the seller does not fulfill its obligation by handing the goods over to the carrier. The seller must deliver the goods to the buyer at the buyer's place of business. So this distinction must be made. And also note that the rights and obligations of the carrier and the consignor or holder of transport documents, such as bill of lading, are not governed by the CISG. They are governed by the applicable rules, applicable law on carriage of the goods. For example, the Hague-Visby rules, or the UNCITRAL-Hamburg rules, or maybe the Montreal Convention for carriage by air. And maybe I should also mention the Rotterdam rules here. So the rights and obligations of the carrier and the consignor, holder of transport documents, is a separate contract that is not governed by the CISG, that is governed by other law that relates to carriage. Now, this is a sale involving carriage of the goods. Now, in carriage, in contract of sale involving carriage of the goods, shipment must be arranged, and in many cases, insurance must be effected. Who is responsible for doing that? Who must arrange for the shipment and insurance? The CISG does not directly answer this question. As for the arrangement of the shipment, the CISG only provides that if the seller is to arrange for shipment, the seller must choose means of transportation that is appropriate in the circumstances and according to the usual terms for such transportation. that is provided in Article 32, paragraph 2. So the CISG is not clear, does not clearly state whether the seller has an obligation to arrange for the goods or whether it is the buyer's responsibility to arrange for the shipment of goods. In my opinion, in my humble opinion, the default rule is that the buyer must arrange for the shipment, because Article 32, paragraph 2 begins with an if the seller is to arrange for shipment, indicating that that is not the default position of the CISG. That is one reason. And also because the general rule in Article 31C, which I will explain shortly, is that it is for the buyer to collect the goods. It is the obligation. It is for the buyer to collect the goods. That is the default position of the CISG. And considering these provisions, my opinion is that it is for the buyer to arrange for the shipment of the goods. As for insurance, the CISG only provides that even if the seller does not have an obligation to effect insurance, the seller must cooperate by providing necessary information to the buyer. Now, so these are not clear who has the responsibility under the CISG, but in practice, parties will usually agree on these issues, on these matters, by using trade terms such as the CIF, FOB, and as are defined by Incoterms of the International Chamber of Commerce, ICC. It is always wise to make it clear in the contract who has the responsibility to arrange for the shipment and who has a responsibility to effect insurance. And by using those trade terms under the Incoterms, that can be done. Also, if I can go back a little bit and talk about the place of delivery, that is also an issue that is covered by Incoterms, trade terms. And by explicitly agreeing in the contract to those trade terms, the parties can clearly define the place, the modality of the delivery as well. Or they can change the default rules under the CISG. Okay. Now let me move on to the next slide. I have been talking about contracts of sale involving carriage of the goods so far. Now, for other sales that do not involve carriage of the goods, what are the rules of delivery on place of delivery under the CISG? Article 31C is the general rule. Article 31C provides that the seller must deliver the goods by placing them at the buyer's disposal at the seller's place of business. So this is an obligation to collect, that the buyer will collect. The buyer must collect the goods at the seller's place of business. That is the default rule, default general rule under the CISG. Article 31B applies if the contract relates to specific goods, unidentified goods to be drawn from a specific stock, or to be manufactured or produced. And if at the time of conclusion of the contract, the parties knew that the goods were at a particular place, or that the goods were to be manufactured or produced at a particular place. So when these two conditions are met, the seller must deliver the goods by placing them at the buyer's disposal at that particular place. So this is a rule that is different from the general rule under 31C. But in either case, it is important that all that the seller has to do is to place the goods at the buyer's disposal, which is to take all necessary steps so that all that is left is at the buyer to pick up the goods. Okay. Now, I would like to make a very brief comment, brief note on passing of the risk. Passing of the risk will be dealt with in the later part of this lecture series. But the point that I want to make here is that the fulfillment of obligation to deliver the goods and the place and time of delivering the goods coincides roughly with the passing of risk to the buyer. So these rules must be considered together. First, if the sale involves carriage of the goods, the risk passes when the seller hands over the goods to the first carrier. That is Article 67, paragraph 1. So this is how the seller would deliver the goods if the sale involves carriage of the goods. So by delivering the goods to the first carrier, the risk passes as well. In other sales, if the place of delivery is a seller's place of business, risk passes when the buyer takes over the goods, when the buyer takes possession of the goods, or if the goods are placed at the buyer's disposal and the buyer commits breach of failure to take delivery. It is an obligation of the buyer to take delivery, and failure to do so is a breach of the buyer. And the risk will pass to the buyer when the buyer commits a failure to take delivery, provided that the goods are already placed at the buyer's disposal. That's Article 69(1), paragraph 1. And if the place of delivery is any other place, that is like Article 31B, in that case, the risk passes when the buyer is aware that the goods are placed at the buyer's disposal. So here, the risk passes a little bit earlier than in this case, where the goods are to be collected at the seller's place of business. Well, this is because if the goods are at the seller's place of business, it can still be said that it is within the sphere of risk of the seller. So here, the risk passes a little bit later than in the case under Article 69(2). Now I move on to the next issue, which is about the costs of delivery. I would like to make a small comment on the costs of delivery. The CISG does not have an express provision on bearing of cost of performance. However, the relevant trade usage, which is applicable through Article 9 CISG, or the general principle underlying the CISG, that is Article 7, paragraph 2, is that the cost of delivery, including cost of packaging the goods, measuring the goods, weighing the goods, these costs must be borne by the seller unless otherwise agreed by the parties. And incidentally, this is a position of the UNCITRAL principles, which has a clear provision on the cost of performance, on who bears the cost of performance. The party who performed must bear the cost of the performance. So and this means that, on the other hand, the buyer will bear the cost of taking over the goods. Now, let me be a little bit more concrete. What about transportation costs, the cost of carriage? The seller bears the transportation costs to the place of delivery. If the seller's obligation to deliver is to hand the goods over to the first carrier, which is a case where the sale involves carriage of the goods. In that case, the seller does not bear the transportation cost beyond that point. It bears the cost to that point, but not beyond that point. Likewise, if the buyer is to collect the goods at a particular place, which is the case when Article 31B or C applies, the seller does not bear the cost of transportation beyond that place. Because by delivering at that place, the seller has already performed. And that's for transportation costs. Now, what about customs duties and export-import licenses? These are the types of costs that arise in international sale of goods when the goods cross borders. If the buyer is to collect the goods at a particular place, which is a case under 31B and C, the buyer bears all costs beyond that point, beyond that place. And in other cases, the seller assumes export-related liabilities, whereas the buyer assumes import-related liabilities. So these are the rules, basic rules relating to costs of delivery. Okay, so far I have been talking about the place and modality of delivery with some note on risk of loss, passing of the risk, and costs of delivery. Now I turn to the time of delivery, which is provided in Article 33, CISG. Article 33 provides that the seller must deliver the goods, A, if a date is fixed by or determinable from the contract on that date, and B, if a period of time is fixed by or determinable from the contract at any time within that period, unless circumstances indicate that the buyer is to choose a date. And in any other case, within a reasonable time after the conclusion of the contract. So if a party, well, in order to apply Article 33A or B, a party asserting that a date or a period for delivery has been agreed upon must prove such agreement. If no date or period is agreed upon or is not proven, is not established, the seller must deliver within a reasonable time after the conclusion of the contract. That is Article 33C. Reasonable time for the purpose of Article 33C means a time adequate in the circumstances, and that depends upon individual cases. That must be determined taking relevant circumstances into consideration, and the relevant circumstances are those that are known to both parties at the time of conclusion of the contract. If the seller requires time in acquiring the goods, and therefore will need time to deliver the goods, that should be made known to the buyer at the time of the conclusion of the contract. Conversely, if the buyer requires urgent delivery of the goods, that should be made known to the seller in order for that circumstance to be considered. So relevant circumstances are those that are known to both parties at the time of conclusion of the contract, and it is always good to convey information. It is always a good advice to parties to convey information about the circumstances in which they are placed. Or more, or even better, it is better to provide an exact date or period for delivery, because these reasonable times, the decision of what the reasonable time may differ, it's not always clear. Okay. Another issue I would like to talk about here is what happens if the seller delivers before the agreed time of delivery. Under Article 52, Paragraph 1, CISG, the buyer, in that case, may either accept or reject early delivery. A buyer who accepts early delivery should still be entitled to damages for extra costs for storage, for example, which is caused by early delivery. In other words, early delivery is a breach of the contract. So delivering before the time agreed in the contract, that is not a performance that complies with the contract. Therefore, that is a breach of the contract and relevant, and therefore the remedies that are available to the non-breaching party is also available here. Or in this case, it will be the buyer who will be resorting to remedies. Okay. Now that was for the time of delivery. Now I move on to the last element of the seller's obligation, which is handing over of documents relating to the goods. Article 34 is the provision that we have to look at. Now I will read the first sentence. If the seller is bound to hand over documents relating to the goods, he must hand them over at the time and place and in the form required by the contract. So the seller must deliver documents relating to the goods. What are these documents relating to the goods in the sense of Article 34? Such documents include, first, documents that will give their holders control of the goods, control over the goods. Examples are bills of lading, dock receipts, and warehouse receipts. So these are documents that the buyer will need to take over the goods or to take possession of the goods from the carrier. And these are clearly documents relating to the goods. But also there are other documents that do not control the property in the goods. They can be insurance policies, commercial invoices, and certificates. Various certificates are used in international sales. Certificates of origin, certificates of weight, contents, or quality. These are also considered to be documents relating to the goods. In the end, what documents are required to be delivered from the seller to the buyer will be determined according to the contract, through the interpretation of the contract. But these are the types of documents that should be delivered under Article 34 of the CISG. Oh, and this is an example of bill of lading, which I have just mentioned as one example of a document that give their holder control over the goods. So it works that the seller will ship the goods through a carrier. The carrier will issue a bill of lading. The seller will send that bill of lading to the buyer, and the buyer will present that bill of lading to the carrier in order to take over the goods. So that's how bills of lading will work. And these are clearly documents that, documents that the seller must hand over to the buyer. Now, I'd like to talk about two more issues that relates to delivery of documents. The first is modalities of handing over the goods. If neither the contract or the trade usages or practices between the parties provide specific modalities for handing over the documents, the seller must tender the documents, I will quote, in such time and in such form as will allow the buyer to take possession of the goods from the carrier when the goods arrive at their destination, brings them through customs in the country of destination, and exercise claims against the carrier or insurance company. So this is a general guideline. And this quotation comes from the Secretariat commentary on the 1978 draft of the CISG. So these are the modalities, well, guideline for modalities of handing over documents relating to the goods. The last issue that I would like to touch upon is what happens if the documents are non-conforming. The handing over of non-conforming documents constitutes a breach of contract to which the normal remedies will apply. What do I mean by non-conforming documents? Examples are invoice, invoice discrepant from the contract. Well, in other words, an invoice where there is discrepancy between the contract price and the price indicated in the invoice. That is one example. Bills of lading, non-negotiable bills of lading will be non-conforming if if an order bills of lading, or in other words, negotiable bills of lading, had to be delivered under the contract. That can be non-conforming documents. That can be a case of non-conforming documents. Also, bill of lading from which it is clear that the goods were loaded on dock instead of below dock. That can be non-conforming documents. These will constitute breach of contract, and normal remedies will apply. Whether they amount to fundamental breach or not, and whether contract avoidance is allowed or not, that is another question, but they do constitute a breach of contract. So these are the basic obligations of the seller under the CISG. With that, I think I still have about 5 more minutes, but that is what I wanted to present to you. And with that, I would like to conclude my lecture on the obligation of the buyer under the CISG. It's very unfortunate that I cannot join you live to answer questions and to engage in discussions, but I hope that you will have a chance to direct questions to the other speakers that are present in Vienna. I thank you very much for your attention, and happy 40th anniversary CISG. Thank you.
So, Professor Sono has covered all the obligations of the seller, but for one point, and it is conformity. We'll be discussing that tomorrow in connection with remedies for breach of contract, because conformity and termination for fundamental breach of contract are so very closely related topics. But before I close it today, does any of you have any questions concerning, yes?
I have a question concerning the SC that we're going to rewrite.
Yes.
What's it going to look like? What kind of topic will be?
You get a case on the application of the CISG, and you have to provide your comments, make basically comment a case. I mean, it's not, then we give you the the exact word count and etc. for the case, and then that will be evaluated. Yes? Yeah, you're expressing your surprise at the fact that the CISG treats these two things separately and deals with passage of risk without dealing with passage of property. As I mentioned before, this was a deliberate decision because it was not possible to find a common solution for passing of title. And the CISG is silent about this, but for the purpose of the sales contract, as you'll see tomorrow and talk about passage of this, it doesn't matter. Because what matters for the sales contract is who bears the risk of loss of damage to the goods from the moment they leave the place of business of the seller and they are delivered to the buyer. That is what really matters for the contract of sale, right? For the purposes of the CISG, right? You see also when I talk tomorrow about conformity of the goods, that the seller has to deliver goods that are free of claims by third parties, including property claims. If it is not free of claims, then you will be prevented from passing title to the goods. But the moment the title passes, that's the thing that the CSG doesn't cover. It covers who bears the risk of loss, and that is related to the contract of carriage of goods. And this flexibility on the CISG is also to accommodate the fact that parties would establish that point of passage of risk in different ways depending on the mode of carriage that would have chosen for the contract. And that is a commercial decision that will make depending on their convenience. That is an important question for the contract of sale, because you want to know that if at which point of time the seller has performed the obligation to deliver the goods, right? And for the CISG, even if the seller would continue being the owner of the goods that are in transit to the buyer, if he has performed the obligation to deliver the goods, he ceases being responsible for loss of the goods from that moment on, right? Then the question of property would be the right of the buyer to possibly sell those goods in transit in between. But the question of risk is treated separately. I understand that may sound surprising to you because in most legal systems, the two things go together. And you have this old Roman rule that says, res perit domino, means a thing is lost to its owner. But the CISG, because it doesn't deal with property, could not use that solution. It uses this other solution, which is the risk passes the moment the seller delivers the goods to the buyer. And delivery depends, as Professor Sono said, on how you choose to structure the transportation. I'll mention that tomorrow, perhaps becomes clear. Thank you very much.